Greetings and salutations, loyal viewers of this channel. My name is Sean, and today we got to talk about what is going down in the state of Minnesota, because last year, Governor Tim Walz signed yet another woke piece of criminal justice reform legislation, and this one in particular is leading to the release of potentially hundreds of murderers throughout the state. So that's what we're going to talk about today. But before we do, I want to thank everybody who supports this channel via actualjusticewarrior.com/join.
Give me the money. Give me the money. Okay?
Two women convicted for their roles in a murder case are now out of prison. They were released this week and may be the very first inmates in Minnesota to have their sentences reduced under new legislation.
So I think it's important for you guys to understand what we're talking about before we move forward. So the law that we're talking about is Minnesota's aiding and abetting statute, specifically aiding and abetting murder, which if you are familiar with the language of this statute, you might determine it to be very similar, if not identical, to felony murder statutes in your particular jurisdiction. And the way that felony murder works, and by the way, I will use them interchangeably throughout the course of this segment, is as follows. You and somebody else decide that you are going to commit a felony, whether it be a bank robbery in the most classic example, and during the course of that bank robbery, one party ends up shooting the teller. Well, under felony murder statute, or aiding and abetting murder, as it is defined in the state of Minnesota, both of you would go down and be held responsible to the same degree because you guys both agreed to participate in the underlying felony, and a possible logical result of that underlying felony would be somebody dying. And that is the way that it worked in the state of Minnesota for the longest period of time. However, George Floyd ends up dying in 2020. A rush of woke criminal justice laws end up getting passed throughout the country, and Minnesota is the epicenter of that. So there have been changes made to this law, essentially making it nearly impossible to convict many common felony murder cases under the previous standard. And on top of that, this statute is retroactive, so that gives defendants or people convicted of these crimes opportunities to appeal and get their sentences reduced, if not thrown out, under the parameters of the new statute.
I'm so sorry. This wasn't supposed to happen. Everything went so fast.
So the headlines and the news segments related to people getting released dates back all the way 7 months to February of this year, where the first successful appeal under the new law let out two women who participated in a crime that resulted in somebody dying, one of which you heard weeping right there on the microphone.
Brianna Martinson and Megan Cater were charged and ultimately pleaded guilty to aiding in the murder of Corey Elder in Bloomington while trying to rob him of drugs in 2017. The women were initially sentenced to matching 13-and-a-half-year prison sentences, even though they did not actually help kill Elder. But the state legislature recently rewrote the laws on aiding and abetting the crime of felony murder. So now only those who directly commit the murder or directly aid them can be charged with the crime. The new law can also be applied retroactively to those already in prison. This week, Martinson and Cater were resentenced on lesser burglary charges and released 2.5 years early.
So right there, we get a perfect example of what we were talking about in terms of the felony murder statute and why it was in effect. These particular women did in fact participate in the robbery of a drug dealer who ultimately ended up dying when a third person initiated the kill against them. However, they all went down for felony murder and they were sentenced to 13 years for their troubles in this particular instance. However, they ended up getting it reduced under this new law, which says that you have to actively participate in the homicide, effectively repealing felony murder. In fact, the exception that was added was as follows. A person may not be held criminally liable for a violation of section 609.185, paragraph A, clause 3, for the death caused by another unless the person intentionally aided, advised, hired, counseled, or conspired with, or otherwise procured the other with intent to cause the death of a human being. And then you have section B, which says a person may not be held criminally liable for a violation of section 609.19, subdivision 2, clause 1, for the death caused by another, unless the person was a major participant in the underlying felony and acted with extreme indifference to the human life. And major participant is redefined as used a deadly weapon during the commission of the underlying felony, or provided a deadly weapon to another participant where it was reasonably foreseeable that the weapon would be used in the underlying felony, or caused substantial bodily harm to another during the commission of the underlying felony. They also have the coerced or hired, which we understand, and they have the impeded another person from preventing the death either by physical action or by threat of physical action where it was reasonably foreseeable that death or great bodily harm would result. So this is what is so troubling about the change in definition of major participant, because in this particular circumstance, let's say you decide to rob a bank with somebody. However, that person is armed and not given a firearm by you, and you are not armed during your participation. Even if you guys planned the robbery together, even if you were well aware that that person was armed, if that person ends up shooting a teller, you are not going to go down for felony murder anymore. That is just not a possibility. And if you don't think that my interpretation of this law is accurate, we actually have a similar yet slightly different scenario that ended up resulting in a release just earlier this week.
I will vacate the sentence, the convictions and sentences.
When the judge's order came down.
And I'm sorry for the reopening of the wound. So late.
The family of Malcolm Cowens watched from across the country.
So right there you have the recent instance that we're talking about that has concerned a lot of prosecutors, because the judge not only vacated the sentence, but also vacated the conviction in this particular felony murder case. And she apologized for reopening these wounds for the family members who have to live with the fact that somebody that was locked up and serving the consequences of their actions will now be released onto the streets. But in reality, because Governor Walz signed this stupid woke piece of legislation and it's retroactive, there's not really a lot the judge can do.
Sorry. I practice this a lot, but it's not right. Anyway.
15 years now after her twin brother's murder. Some words still hard to find. Others, though, are not.
There will be no forgiveness or forgetting.
Rosalind McDonald Richards was convicted of aiding and abetting first-degree murder in the deadly 2009 Richfield pawn shop shooting of Cowens, a local boxer who was struck in the back attempting to flee. She was sentenced to life behind bars.
Now, there may be some differences of opinion for those of you out there in my audience on this particular case, so I will give you the parameters of this so you can understand and maybe decide whether or not you think felony murder charges are warranted. But under the law, it was completely unambiguous that they definitely were prior to this change in the law. So Rosalind was acting as the getaway driver during this particular armed robbery. You have the victim who ended up trying to flee for his life because a man comes in with a gun trying to rob the place, and he is shot in the back, dies in cold blood, ends up escaping in the vehicle with Rosalind, who is perfectly fine with the fact that she just heard a gunshot and she drives away with her co-conspirator. So again, like the bank robber example, you're an active participant in a crime that has a reasonable chance that somebody could die, somebody does die, she ends up getting tagged with felony murder charges. But now she's released because I guess being a getaway driver is not all that serious anymore because the statute has been amended.
But the 72-year-old is now a free woman.
Rosalind, may I ask you what these first few steps feel like?
She's no comment today. She's happy to be going home.
We were there. She walked out of the Shakopee prison in May.
It's not an exoneration.
Criminal defense attorneys Anders Erickson and Pete Johnson represented Rosalind, believed to be the very first to have a life sentence tossed as part of the new state law that went into effect about a year ago.
This new law is meant for the people who never intended to kill anyone, did not kill anyone.
So look, I got no hate for the defense attorneys right here. It is their job to advocate for their client, and they even start off by saying that this is not an exoneration, and considering all the different various innocence fraud style movements across this country, I find that to be a bit of a reprieve to hear. But then they start to argue that, hey, look, they never intended to kill anyone, they didn't participate in that portion of the crime or whatever, but the fact of the matter is, that's not why we had the aiding and abetting statute. That's not why we had felony murder. The idea that you intended to participate in a felony that was dangerous, that could result in somebody dying, that intent was believed to be enough in order to make that charge.
Fox 9 examined court records from 165 cases since the law change. More than half of the preliminary petitions for relief rejected on the front end. Judges have found 20 warrant more scrutiny. 11, including Rosalind, had their original sentences vacated.
So yeah, right there he lays out some of the numbers. You have 11 vacations as of right now in this moment. You have 20 cases that warrant more scrutiny and a bunch of different other cases that they believe will stand up to scrutiny even with the new law.
They're the masterminds behind the entire crime. They set it up. They arranged for there to be a gun.
4 of those cases are directly connected to the 2017 Bloomington murder of Bobby Elder's son, Corey.
We would not be here right now if it wasn't for their actions.
The group released from prison early with the support of Hennepin County Attorney Mary Moriarty.
Then they end up interviewing somebody related to the previous case that we were talking about, where those 2 girls got their conviction vacated, and she's arguing that these are the people who planned the robbery that ultimately ended up leading to the murder, and she believes that they should be held responsible for their participation in that crime. But again, under this law, even though you can technically still charge a murder conspiracy under this abetting statute, the fact of the matter is those charges are less likely to stick due to the limitations that they put on what a major participant actually is.
We're not talking about people who are innocent of everything. We're just recognizing exactly the role that they played.
So unsurprisingly, Mary Moriarty, the district attorney for Hennepin County, who took power post the Black Lives Matter riots, is in favor of this new law, and this should not be shocking to anyone, because even when she still has the ability to charge people under the old law, like in that case that we covered where the white kid got 22 years but the Native American kid got time served, she refused to do so. If you guys will recall, Braveheart in that case, the Native American kid, also fired shots onto the person that they were carjacking, but since the lethal shot came from the white kid, he ended up getting 22 years, and this guy was offered a sweetheart plea deal where he ended up with time served. And by the way, in case you guys are wondering, that Braveheart kid has already been rearrested in a stolen car, very similar set of circumstances, and he had a previous history of armed robberies, so that could have been an instance where he was the ringleader in that crime. He fired shots with intent to kill on the victim of that crime and got lucky based on the fact that he's from a protected group that Moriarty never wants to prosecute. So when I hear Moriarty talk about, oh, well, these people didn't kill anyone, it's completely different, and it's not a situation where they were even intending to. I just want you guys to understand that even when they intend to commit murder and they fit under this narrowly tailored felony murder statute, she refuses to charge them and she will let them out with time served.
But in Scott County,
we're fighting it. We're fighting it to have these convictions maintained.
County Attorney Ron Hocevar is now appealing 2 cases where offenders were resentenced on lesser charges, arguing the law change is, quote, odd and unconstitutional.
There's no finality there. There's no finality to the case. There's no finality for the victims to move forward. And it's just, we believe that is unconstitutional.
Now, by contrast, the Scott County District Attorney is fighting against this law. They're fighting to have these cases, convictions remain, and they also want to have it overturned. But this is the predicament that Governor Tim Walz had put the citizens of the state of Minnesota in by signing these woke pieces of legislation in order to improve his credibility with these criminal types and the pro-criminal types. And the consequences are absolutely devastating, not just for the families, but for the potential future victims that would not have been harmed, that would not have been victimized by criminals that would have been locked up the first time that their crime got out of hand, and that ended up resulting in a death.
And this new law, which is we think is great, is it's taking a step back and it's saying, look, some of these people were less culpable than the person who had the intent to kill and actually did kill somebody.
Attorneys Erickson and Johnson believe the new law helped right a wrong. Rosalind was serving a life sentence as a co-conspirator and getaway driver in a planned robbery following a jury's guilty verdict, while the actual trigger man, caught on camera here, got 33 years in prison as part of a plea deal.
Now, to this particular point right here, I do want to say it does seem rather unfair that she ended up with life in prison and the other guy ended up with 33 years in prison. However, I do want to point out that she took it to a jury trial, and usually that results in you being sentenced to the maximum, and the other guy took a plea bargain. That being said, we're not talking about resentencing her to even an equivalent sentence of this individual. We're talking about a vacation of her conviction based on the idea that, oh, well, you know, it's not that big of a deal, and honestly, she only intended to participate in the armed robbery, so who cares? And the family kind of expresses this notion very properly, in my opinion.
Rosalind McDonald Richards knew what she was doing. This was free will, including the knowledge of firearms and the potential high-risk outcomes.
Meantime, the victim's family believes the system failed them.
Initially, justice prevailed. Unfortunately, now there has been a reversal.
So yeah, she talks about the fact that this woman knew she was involved. The idea that she wasn't a participant in something that could have clearly and obviously gotten out of hand is ridiculous and absurd. And I hate to take a middle ground position on this particular issue, but in my opinion, especially since we're talking about a woman who's 72 years old, the idea of her serving life when the other guy gets 33 years, I actually don't agree with. I think you have to kind of maximum cap her sentence at where his sentence is in order to be fair, because you're in a situation where he gets less time for committing the crime and you get more time for participating in the underlying crime. And that's not something that I'm on board with, even though there is a logical explanation for it in that she fought the charges and lost to a jury, and this guy ended up taking a plea bargain because the evidence was overwhelming against him.
So this isn't some sort of celebration at the end of the day. It's somebody who served a long prison sentence, is now getting a shorter prison sentence, sometimes being released from prison, which we think is the way the law should work, but it's not some sort of celebration at the end of the day where somebody's exonerated from a crime.
Now again, I give credit to the defense attorneys in this particular case because even though they're supportive of the law, they make a reasonable argument related to this. One of the problems I have with all these innocence fraud death penalty cases is that rather than saying that they're against the death penalty and being honest about it, they go through all these elaborate conspiracies on why the guy is actually innocent, even though the evidence is overwhelming against him. I mean, look at the Marcellus Williams case that I covered in a video just recently. But I want to know what you guys think down in the comments below. Do you think these changes to the felony murder statute are actually good, solid, sensible changes? Or do you believe that this is just another pillar in our criminal justice system being removed in order to aid and abet, ironically, the criminals? If you like this video, show me by leaving a like, subscribe for more content, follow me on my social medias, support me via the support links in the description of this video. This has been me talking about Minnesota's new felony murder statute. Till next time.